Next, civil court jurisdiction. Now, there is a controversy even now whether civil court has jurisdiction on industrial law matters. In 1975, in Premier Automobile, Supreme Court clarified, laying down 4 principles, the important principle being, if the subject matter of an industrial law is there, civil courts will not have a jurisdiction. But if the subject matter of industrial law is not a codified one, but it can also be a common law, civil court jurisdiction is available. So where the labor jurisdiction ends or where the common law jurisdiction starts itself was a debate. A number of judgments have been given. In the inquiry whether it can be challenged, they said yes. But in a non-employment, no. In a reinstatement, no. But in compensation, yes. So there was a lot of confusion by the High Court and Supreme Court also. But this court says explicitly that civil court would have no jurisdiction on in respect of IR court. It is a good suggestion which should be accepted and appreciated. Yes, next. So this part of his concern, the Farmer Industrial Disputes Act. Now we will come to a Trade Union Act. I was really wondering from 1926, we are in 2020, for nearly 100 years, why this Trade Union Act did not move forward at all, in spite of trade unions being there for more than 100 years. Till the Madras MLU is more than 100 years old, which is started in Chennai. There was no clear thought on the recognition, registration, etc. This code really addresses it. Now, the registration and the continued registration to be alive has been made still by the code. Next. Next. Trade union is also been now on a central law, there is no law on recognition. It is not good either for the workman or for the management. It may lead to a lot of chaos. Now recognition has been made mandatory and also has been transparent. Now, if there is waste subject to the criteria to be prescribed by the government, then there is more than one trade union, a union which commands 51% of the members recognized as a source. No 51%, clear-cut idea, only one union, it is recognized. 51% recognized. No 51%, 20% is recognized. So we have a clear idea how to go about recognition. There is no favoritism or a minority union trying to claim recognition, etc. And this recognition is valid for 3 years or by consent for 5 years. So this gives a good indication of union movement being recognized, and it is no more favoritism nor one hijacking the other, and becomes very clear. Next, some points on the standing orders. 12. Standing orders is a minor subject. Here it is in respect of 300 or more workmen. Standing orders is made compulsorily applicable. But the question remains, what happens if your establishment is less than 300? It should be addressed. Next. Now, if there is no standing order, the model is there. The model will apply definitely, or the employer has got an option to adopt it as it is. Undergoing the process of ordeal of certification, etc., he can simply adopt it. Next. Next. Observations. Now, drafting of standing orders has been made. Standing orders have been simplified. Only Faisal will go back. 14. Drafting of standing orders has been simplified. It should be done within 60 days, failing which it should have been deemed to have been certified. So some right direction under the Standing Orders Act has taken place. Next. So these are the 14 highlights, I should say. 15-20 minutes given to me. Next,